Okay, well, welcome everybody to this panel on the International Criminal Court. I'm David Luban. I'm a professor of law here at Georgetown University. The International Criminal Court, the ICC, has been in the news quite a bit lately. It has a profoundly important mission. It's the world's only permanent court for the core crimes of genocide, war crimes, crimes against humanity, and aggression. And in fact, as the other international tribunals are gradually winding down their business, the ICC will soon be the only such court. Now, I'm sure that many of you in the audience today know a lot about the ICC, but before introducing our panelists, I'd like to go through a few ICC basics for those who aren't familiar with its distinctive legal features. So the ICC was created by a 1998 treaty known as the Rome Statute, and it opened for business in The Hague in 2002. Today it has 123 member states, which is about 2/3 of all the states in the world, and they come from all areas of the world. I want to just mention two important points about how the ICC works. First, it operates on a principle called complementarity. That means that the job of the ICC is not to replace domestic prosecutions and investigations, but to complement them and to backstop them. And in practice, that means that the ICC can only step in, can only admit a case if a state that's in its jurisdiction is unwilling or unable to investigate and prosecute the alleged core crimes on its own. And second, very important, it's a court with limited jurisdiction. It can only prosecute crimes committed on the territory of its member states or committed by their nationals. And the legal theory behind this limit is that the members have delegated to the ICC their own territorial and nationality jurisdiction over the core crimes in the event that they're unwilling or unable to investigate and prosecute. In practice, that means the ICC can't investigate core crimes that take place in non-member states. For example, as you heard from Beth Van Skak this morning, crimes committed in Syria over the past 10 years. Now, several of the major powers in the world don't belong to the ICC. That includes 3 of the 5 permanent members of the UN Security Council: China, Russia, the United States. None has ever joined the ICC. Now, I think that most of you know that the prosecutor is currently authorized to investigate the United States. And given what I just said, you might wonder how it can investigate a non-member, especially over our own government's objections. We'll be talking about this today. But for now, I'll just give the short answer. The investigation is about what US personnel are alleged to have done in the territory of ICC member states, alleged torture in Afghanistan, Lithuania, Poland, and Romania. Now, at the moment, the prosecutor is investigating 13 situations. A situation includes the possibility of many specific crimes by all sides. They're in Africa, they're in the Middle East, they're in Europe, and she's in the midst of preliminary examinations of half a dozen other situations in 4 continents. At the moment, the court has 18 active cases, 4 ongoing trials, and unfortunately, a dozen suspects who are still at large. It's completed 14 cases. The track record is 4 convictions, 3 acquittals, 4 cases were dismissed, and 3 were withdrawn without prejudice, meaning that the prosecutor can activate them again in the future. Now, at this point, I'd like to introduce our terrific group of panelists. Todd Buchwald served as ambassador and special coordinator for global criminal justice in the US State Department from 2015 to 2017 after a distinguished career in the State Department's legal advisor. Currently, he's a professorial lecturer at George Washington University Law School. Margaret deGuzman, Meg to her friends, is the James E. Beasley Professor of Law at Temple University, where she co-directs the Institute for International Law and Public Policy. She's also a senior peace fellow at the Public International Law and Policy Group. She published a recent book called Shocking the Conscience of Humanity, Gravity, and the Legitimacy of International Criminal Law, and also edited the Elgar Companion to the International Criminal Court. Charles Jalloh is professor of law at Florida International University. He's had a distinguished career both as a practitioner and prolific scholar of international criminal law. Among other things, he is the founding editor of the African Journal of International Criminal Justice, and he currently serves on the International Law Commission, the UN's official body for developing and codifying international law. Now, our plan today is to do this as a roundtable discussion rather than have formal presentations at the by the panelists. And I want to just start with a question that's drawn directly from the headlines. Those of you who've been following the news know that last week, President Biden rescinded sanctions that had been imposed on the prosecutor and one other official at the ICC, and withdrew President Trump's executive order that had declared the ICC investigations a national emergency and imposed sanctions. Now, I'm going to ask this question of Meg to describe, to explain the sanctions issue to us, and also to tell us something about the lawsuit that you were involved in.
Sure. Thanks so much, David. And let me just start by thanking you and Melissa and Jane for including me in this really significant, timely conference. It's a particular honor to be here in light of the fact that the honoree of the conference, Professor Dash, attended Temple University and then went on to teach at Georgetown. And I attended Georgetown and went on to teach at Temple. So we have that synergy going on. So let me get to your question. Let me start with a little bit of background on the use of sanctions in US foreign policy. So sanctions like economic restrictions and travel bans have become a very important tool of US foreign policy, particularly in recent years. And they can be authorized by the president or by Congress. But Congress has delegated to the president the ability to authorize sanctions through emergency powers. And in particular, the International Emergency Economic Powers Act, or IEPA, allows the president to institute sanctions upon declaring a national emergency with respect to an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. Courts have held that the president has wide discretion in declaring a situation to be such a national emergency. And presidents have used this power in a variety of settings, including to combat terrorism, nuclear proliferation, narcotics trafficking, and importantly for our purposes, to fight serious human rights abuses. Some of the sanctions that have been issued that relate to human rights abuses are country specific, and they've been issued against countries like Belarus, Burundi, Cuba, Iran, North Korea, Sudan, and others. And some target specific individuals. And in particular, the Global Magnitsky Human Rights Accountability Act allows for sanctions against foreign persons responsible for gross violations of internationally recognized human rights. And a number of individuals have been targeted here. So this is the setting that then I want you to consider when you think about what the Trump administration did last June when it issued Executive Order 13,928, to give you a sense of how many there are out there. He used this IEPA power to declare that the International Criminal Court constitutes a threat to US national security. In fact, an extraordinary threat to the national security, foreign policy, or economy of the United States by virtue of its investigation and prospective prosecutions of US citizens and the citizens of nationals of allies of the United States that are also not parties to the ICC. So the order then authorized the Secretary of State to designate any foreign person who has directly or indirectly engaged in any effort by the ICC to investigate or prosecute US personnel or the personnel of US allies without that government's consent. Then in September, Secretary of State Pompeo designated 2 individuals under this order, the prosecutor of the ICC, Fatou Bensouda, and one of her deputies, Fakiso Motochoku, who's the head of the Office of the Prosecutor's Jurisdiction and Complementarity and Cooperation Division. So this executive order also permitted the designation of any foreign person who engages with a designated person. And that kind of, the engagement envisioned included providing material assistance, material support, or services to or in support of the designees. The order failed to define these terms like foreign person and material support. And as such, it threatened a very broad range of persons and of activities. And particularly relevant for the lawsuit that I was a part of, or am a part of, foreign persons in the context of other sanctions issued under IEEPA has been defined to include persons with dual citizenship. So this meant that those of us who provide any kind of assistance to the Office of the Prosecutor could be designated and therefore subject to the same kinds of sanctions that she was subject to, which includes very significant financial penalties, the freezing of all of our assets, the inability to transact in any financial transaction that involves US dollars. And if you think about the fact that most of the world's financial transactions go through the US dollar system at some point, this means, for example, not being able to use most credit cards and to interact with many kinds of financial institutions. In addition to the possibility of being designated for our own sanctions, the executive order also meant that both foreign persons and US citizens could have penalties enforced against them if they violated the executive order, for example, by transacting with a designated person. And the sanctions there could be penalties of $300,000 or twice the value of the transaction, the illegal transaction with the designated person, criminal penalties of up to $1 million, and up to 20 years in prison. Okay, so to give you a sense of, we're talking about very significant consequences, both for being designated, which some people have termed or likened to civil death because of how much it restricts one's ability to operate in society, as well as for having enforcement penalties brought against one, which could include this prison sentence and so forth. So this basically meant that IEEPA sanctions, which in the past had been used, as I said before, to target, massive human rights violators, terrorists, drug traffickers, et cetera, was now being used to target the ICC, right? People who were dedicating their lives to fighting serious human rights abuses were now being targeted with these sanctions that had heretofore been used against people engaged in human rights abuses. So this generated a fair bit of outrage in the international community. A lot of countries spoke out against the sanctions, and it gave rise to the lawsuit that David referred to a moment ago that was brought in October, led by the Open Society Justice Initiative, and also joined in by myself and 3 other law professors each of whom is a dual citizen and therefore potentially subject to designation under the order. And very ably represented by Melissa's former colleagues at Foley, we brought the lawsuit in the Southern District of New York, and then also filed for a preliminary injunction asking the court to stay enforcement of the executive order against the plaintiffs pending resolution of the litigation. So we challenged the executive order on several grounds, including that it violated our First Amendment rights to free speech and association. The plaintiffs, all of us, engage in what could be deemed to be assisting the court through things like this, conferences, panels, where we give opinions that could be construed as advice to the ICC. And in fact, as I'll say shortly, that the executive order was withdrawn just in the nick of time for me to be able to say some of the more substantive things that I wanted to contribute to today's panel, because I wasn't up until now, after the June when the order was issued, my ability to talk at conferences, to publish things, to provide amicus curiae to the court, et cetera, has been severely limited. So the court actually, I should also mention, we also challenged the order on due process grounds and as on the basis that the president had exceeded his authority. So then on January 4th, the court actually granted our preliminary injunction in part, holding that the government could not enforce sanctions against us based on a likelihood that we would succeed, in particular in our First Amendment challenges. But it was only granted in part. It did not apply to the possibility that we would be designated. The court found that that wasn't quite ripe, that the government had sort of implicitly said it wasn't going to designate us, but it wasn't a firm enough holding for us to feel particularly comfortable speaking out at that point. So when the Biden administration was elected, many of us hoped, and I think at least in my case, frankly, assumed that the executive order would be withdrawn immediately, right? This seemed like a classic Trump action that was going to be reversed right away by the new administration. And in fact, I wrote something on UCLA's ICC forum arguing that this should be a day one action that the administration should take. Well, that didn't happen. And as I say, it wasn't until this past Friday that President Biden issued an order revoking the executive order. And this seems to be significantly, I'm not on the inside here, but looking at this from the outside, this seems to potentially be linked to the fact that on March 3rd, the prosecutor announced that she was opening an investigation into the situation in Palestine. And even in February, the court had issued a decision saying that the court's jurisdiction extended to that situation. And so this seems to have influenced the administration, again, without any inside knowledge, just looking at this from the outside, to keep the order on the books for several months. And then finally it was revoked on Friday. And it appears that Friday was the day because the government's response to our complaint was due today. So that seems to have influenced the timing of the events. And I should mention there was also another lawsuit brought by the ACLU and another group of law professors that no doubt was also consequential. So let me just close by saying I'm obviously thrilled that the order was withdrawn. I think many people are, both at home and around the world and at the ICC itself. I am disappointed that it took so long. I think that the administration should be very clear about its repudiation of this idea that these kinds of sanctions can be used in this way to target those who are seeking to uphold and achieve justice rather than to undermine it. And so I hope that more will be forthcoming from this administration that suggests that it wants to, reassert our moral leadership in the world and uphold the rule of law. And I will leave it there.
Well, thanks, Meg. that does raise the larger question about what the United States posture, the Biden administration's posture toward the ICC is going forward. And is, the United States has, with different administrations, blown, I won't say hot and cold on the ICC, but lukewarm or tepid and cold. And I'm wondering if, Todd, if you would be willing to give us an overview of what you think the new administration's policy is going to be and what you think it should be. I think you're muted.
Well, that completes my answer for the question. No, I was just thanking everybody for the opportunity to speak, David and Melissa and the Institute and so forth. I think it's all in the category of to be decided, and a lot of it will depend on how events unfold. I don't think you could get an answer right now of, a prediction in which you could feel totally confident. But I think some of the broad contours are coming out. Just to say, I too lobbied pretty vigorously for the repeal, the revocation of the sanctions at the beginning. It just seemed to me that was, for exactly the reasons Meg said, it's just like, this is not the way we do business. This is not a hard question. Just, this is a Trump era excess. Go away. Whatever we think about the ICC, this is not the way we should be doing business. And was disappointed that it didn't happen. That said, watching the way this is playing out, I'm not sure that it won't have its advantages. It may have its advantages precisely because it was done in a way that was considered and deliberate. The statements that the secretary and the president made, or the statement that the secretary made in the president's executive order revoking the sanctions, gives some good hints about what's ahead. So both of them called the sanctions ineffective and inappropriate. And I, for one, thought that the inappropriate part was very important. That's the message that I thought needed to come through at the beginning, that this is not the way the United States is going to do business. I do think it's code for that. The statements emphasized our support for the rule of law, and not only emphasized them, but identified them as national security interests. And I think that's important too. And it said that the administration maintains its strong disagreements about the Afghanistan and Palestine investigations. Of course it does. And the president said in his executive order, he said, we'll vigorously protect US personnel. But they said that we can and should address our concerns in a principled way. I think their words were, we should engage all stakeholders in the ICC process. And that's a very different way of addressing our concerns than we saw in the previous administration. I think that's very important. And then finally, it said that I think Secretary Blinken said that we're encouraged that the ICC parties are considering a broad range of reforms to better prioritize how it channels its resources, and said this reform is a worthwhile effort. And I think that's exactly where they need to be and need to get to. That's a message of engagement, a message of being constructive. It's a far cry from the previous administration, whose goal was, assuming that the Rome Statute parties did not amend the Rome Statute to make it impossible to exercise jurisdiction over Americans or nationals of any country that is not a Rome Statute party. The previous administration's stated goal was to seek the dissolution of the court. So a very, very different message. As for where we go from here, the Afghanistan situation and the Palestine situation are not going to go away quickly. You heard I said before, we'll vigorously protect the past and current US personnel. And I do think so long as Afghanistan and Palestine are sort of perceived as lurking, support from the administration for ICC cases will be limited. They've used the words extraordinary cases, in which they still might provide support, notwithstanding the existence of these two investigations. We don't know exactly what that means. We don't know what it will end up meaning, but it's not going to go back to the situation as it was at the end of the Obama administration. And in truth, at the end of the Obama administration, it wasn't the way it was a year or two before then, as Afghanistan and Palestine started to sort of come into focus. So I think, though, that for the good, ICC policy is not going to be sort of made in a vacuum. It's not just ICC policy. ICC policy is sort of a small part of the administration's policy towards multilateral engagement, towards international institutions, towards the rule of law. So it'll be sort of carried on currents that are determined by the sort of the bigger way that the administration wants to project itself. And I think those are all for the positive. So I think that will drive the administration towards engagement, right? I assume we'll return going to the Assembly of States Parties meetings, for example, in a way, hopefully with an ambassador at large, leading a delegation, this kind of thing. And we'll want to present ourselves as engaged, as not rooting for the destruction of the court, that we want to engage in a way that allows us to maintain as much of a voice as we can on promoting accountability and human rights and the international rule of law. And I don't think we'll defend our positions unvigorously, but I think we'll present them in sort of a reasoned kind of way. Maybe I should leave it there, but we can get back to this a little bit later, more specifics about Afghanistan itself.
Yeah, thank you. So just for those in the audience who are not familiar with what the investigation of the situation in Afghanistan is, it actually involves an investigation of possible crimes by the Taliban, by Afghan national forces, and by U.S. forces, and specifically the crimes, most of the crimes under investigation by U.S. forces had to do with the CIA's torture program in the early 2000s in black sites. Afghanistan is a state party to the Rome Statute, and so are the 3 European nations where the black sites were located, and that's kind of what the situation is about. And let me just ask one follow-up, Todd. Am I right in assuming that the United States is not going to cooperate with the investigation?
They certainly won't cooperate. What they do to engage is a different question, but they won't call it cooperation, but but that doesn't really sort of, they won't put that label on it.
Yeah. Okay. Thanks. So, I think the other big piece of news about the ICC is that Fatou Bensouda's term as prosecutor is coming to a close. And the new prosecutor, the British barrister Karim Khan, who is an experienced ICC defense lawyer, as well as many other things, is going to assume his duties. And this is a question that I'd like to ask you, Charles. What can we expect from the new prosecutor? What will we expect a change of approach? And just to make it a bit more specific, there've been a few setbacks in prosecutions under Madame Bensouda and also under her predecessor, Luis Moreno Ocampo. And here I'm thinking of the Bemba case, in which there was an acquittal with some of the judges saying that the case had just not proven anything beyond a reasonable doubt, or the Gbagbo and Blegude cases where the court said there was really no case to answer. How do you think that the new prosecutor is going to approach cases? And then maybe you could say something about what the new prosecutor is going to do with this, with these hot potatoes and the situation in Afghanistan and the situation in Palestine.
Thank you so much, David. Let me use this opportunity to thank the organizers for inviting me to be part of this really important conversation in honor of Professor Samuel Dash and his important contributions to international and domestic human rights. I must confess I have a little bit of nostalgia, and perhaps it's a little bit provoked by COVID-19, because I remember the first opportunity I had in 2017 to come up to Georgetown and talk about issues of international justice. And of course, now I have to do it all from behind the screen. Nevertheless, it's a great delight to be here. So thank you to you, David, and of course, Jane Stromset, and Melissa Stewart, who's been working very hard, and along with a whole host of other people, I'm sure, in the background, putting all of this together. I remember really some really stimulating conversations from 2017, and just following the opening this morning, the opening panel, the keynote speech, and that conversation that followed afterwards, I realized, of course, I'm not really losing much. So maybe I'm missing a little bit of that personal contact, but in terms of the scholarly debate, I've already really been fulfilled, so to speak. Just before I get to your questions, David, that were directed to me, let me just underscore a couple of points that Meg made about this really incredible, I think, lawsuit that was brought by the Open Society Justice Initiative, and of course, Meg deGuzman and Dan Marieman and Milan Mysterio and Gabo Rona, amongst now a bunch of other litigation. As to, if you will, the surprise that this wasn't one of the first measures. I thought when we were hearing about the return to multilateralism and the whole WHO re-entry by the US, the Paris Agreement in terms of climate change, that another measure that would be included there would be basically the rescission of this really stunning executive order, unprecedented, at least in my own lifetime, in terms of what is really a fundamentally historically important US role towards international justice. I listened a lot earlier to Philip Sands talking about how everything basically leads back to Nuremberg. Well, when you go back, if that's true, you find the United States there, right? I mean, Stalin and Churchill had their own views about what to do with the Nazis. But of course, the US came in, Justice Jackson at the background, but of course, President Roosevelt really pushing the very idea of international criminal justice. And if you fast forward to today and where we are, if you think about all the modern efforts, whether it's the Rwanda Tribunal, of course, Yugoslav Tribunal, Special Court Professorial, the United States is so prominent in those efforts that I think I needed to say that in fact, this is a long trajectory of strong support from the United States. In terms of financing those institutions, if you think about all these hybrid courts and even the Chapter 7 tribunal, so a really significant role that I hope, and this will go to the second point that I think Todd was talking about, in terms of now what it means. Perhaps it hope for me would mean a shift towards a more constructive engagement. That allows the US to do things like, take credit for the Nataganda kind of outcome, where you had the United States playing such a prominent role in getting this individual who wanted to, if he was surrendered to the US Embassy in Kigali. That's the kind of constructive engagement that the US can really play for the ICC. Anyway, I think I've said enough on that. I think the experts before me have already covered that very well, but I did want to underline that I hope, at least from where I'm sitting as an observer in this area, that this will really be the return of a strong policy of multilateralism and engagement with international institutions that Todd talked about, that really also brings in the ICC and keeps that longer historical trajectory of the United States' fundamental role in this area, not to make it open season for crackpot countries and dictatorships to, if you will, attack the court for political reasons. To your question, David, in terms of what we can expect from the new prosecutor, in terms of potential changes and perhaps even new directions, I think it's fair to say that I don't have any special scoop, but as an academic observer of the ICC, we all know that it has been incredibly challenging time for the ICC, including obviously for the office of the prosecutor, which sits at the center of all of this. There have also been some accomplishments of Prosecutor Bensouda under her term in terms of the number of cases that were successful, few though they may be, and also obviously the adoption of a set of policies by the Office of the Prosecutor that set out some key priorities that really have shaped, and we saw some dividends, if you will, stemming from those priorities, including the most recent version of our policy strategic plan that covers the last couple of years between 2019 and 2021, which will basically reflect and was timed such as to reflect the end of her mandate. And what you'll notice is that she basically prioritized 6 things. I'm not going to get into the detail of all of them, but I do want to just very quickly review those, because in a way, the office of the prosecutor will remain, right? So you have the institutional apparatus that sits behind. So what is changing essentially to some extent is the leadership at the top. Obviously, very significant. The prosecutor would come in, and then about a year later, we're expecting we'll get a deputy prosecutor. But in a way, one would also expect that they would look at what they've met, especially things that have been successful. If you start with the first priority, which is basically to achieve a high rate of success in the court in terms of cases, I think that really, in a sense, answers to that critique of failed cases that we've seen from the OTP. They got successes in the Almaty case. And then you have, of course, the problem you have Bemba and you have Nataganda. All of this really resulted from a change when she took over the office in 2012, where she really tried to do more in-depth, open-ended investigations, where she tried to emphasize being trial ready in the proceedings and not later than the confirmation of charges stage, and then finally focusing on the most responsible perpetrators, and if need be, building up an upwards kind of strategy. I think that is a big thing that happened in the OTP. I will expect that the new prosecutor, Mr. Khan, as with all his experience in tribunal, will look at that very seriously in terms of a policy that he might maintain. On the flip side, of course, you mentioned, David, some of the more challenging cases for the OTP, the collapse of the Ruto Sang cases, the Bemba main case, and of course, the Bagbo Blegude case, which we know just last week, the appeals chamber issued a decision effectively upholding the acquittal. Now, part of the challenge, of course, was there wasn't a sufficient evidentiary basis there. But I do want to note that there have been some challenges for the OTP that are not just, if you will, at the doorstep of the OTP in terms of state support. I mean, in some cases, actual undermining by the governments in the situation countries concerned of the cases that they were trying to build. And obviously, the even decision of the prosecutor to withdraw and hold in abeyance, if you will, without prejudice, the cases from the Kenya situation is just a case in point. So the issue of state cooperation, in other words, sits in the backdrop. And one of the issues that goes with that, of course, is the element of how much support the prosecutor is getting in terms of funding. And that is one of the huge challenges that she said, in fact, is her biggest challenge in her term. And I imagine will be a challenge also for the incoming prosecutor. Let me just highlight a couple of other things that she's tried to do. So strategic goal 2 is to basically increase the speed and efficiency of the preliminary examinations. And there, to her credit, the prosecutor tried to wrap up as many of the preliminary examinations as possible. And in 2019, she announced that she would make a decision on quite a few of those. And she's been able to actually do that in respect of at least 4 situations. If you think about the long-running investigation concerning Iraq and the UK, the ongoing preliminary examination in Nigeria, the third one concerning Ukraine, and a fourth and final one that I think Meg mentioned earlier concerning Palestine. Of course, the office has opened some new ones referred by states. If you think about the Bolivia and Venezuela situations. And of course, now we have, with the appeals chamber upholding or reversal of the decision of the pretrial chamber, the possibility that the court would act in Afghanistan. I shift from that to say, if you think about the third strategy, which is to enhance the methodologies and increase the rate of arrest, I think this is clear that the court has struggled here. And I think that is very obvious to all of us who follow international justice that it's not the ICC that can arrest the suspects. They have 45 suspects. At this stage, 15 suspects in 6 different situation countries remain at large. And from the court's perspective, getting the cooperation is critical to ensure that those individuals are transferred to the court and be able to face, if you will, their day in court in terms of defending against the crimes of which they have been accused. And clearly here, this is, if you will, an issue for the Assembly of States parties as much as it is for the OTP and the court as a whole, because there's that level of concern now that as you build more cases on the docket and unenforced arrest warrants, it may well undermine the presumed deterrent effect of the court. If I go very quickly to the last couple of points that I wanted to stress, if you think about the change in policy towards focusing on approach to victims in regards to victims of sexual and gender-based violence and crimes against children, I don't think that I do not expect a lot of change there. I think the OTP has done a lot of work there, including the new policy papers we've seen in that area. The fifth strategic goal, which is really about internal in-house managerial effectiveness and so on, I think she's done a great job there. And this will be some areas that, if you tie it to the discussion of the independent review process, there will be a lot of work for the OTP to do under new leadership. And then the final one is about the strategic placement of the OTP in a wider system that is predicated on the complementarity that you talked about earlier, David, which really basically lifts the burden to national systems. And I guess there's big expectations about positive complementarity and a little bit of pushing back now from the OTP saying, look, we have very limited resources. Our role is not to engage in positive complementarity to the point that will provide you all the support, because we just don't have that. Our role is to, if you will, support your initiatives to ensure that some justice is done. So all in all, I would say, if you think about the current priorities of the OTP, you think of the fact that much has been accomplished, and yet we've also seen some challenges. I expect the new prosecutor to come in and basically revisit this policy, especially the last strategic plan, very carefully before he makes any fundamental shifts. He's a very experienced lawyer. He's come from a long experience in international tribunals. I hope that he will get the support from the states parties with a little bit of wind behind his back to make some changes if he feels those are necessary. I do think, though, that the most critical elements will be dealing with that funding crunch, where the OTPs has to do more with less, and it's not sustainable, according to Prosecutor Bensouda. She said that's been our biggest challenge, leaving aside the political context. And then that second point about making sure that the court, if you will, gets some successes in the court, because that's what will give the confidence to states perhaps to put more money in the ICC. So let me leave it at that. I've gone a little bit longer than I wanted to, but I hope that covers at least some of the key points that would hopefully generate a bit of discussion afterwards. Thank you very much.
Yeah, thank you. And if I could just ask one follow-up, between the two roles of the prosecutor as a lawyer slash prosecutor, and as a diplomat, how do you think that those are allocated? I mean, is that a 50-50 job? Is it a 60-40 job?
Honestly, David, your guess is as good as mine, but I think it's more like a 60-40, right? In a way, if you think about the role of the prosecutor who sits atop this very complex organization with a lot of staff, one of the things that I'm hopeful about in terms of potential changes we might see is actually have two deputy prosecutors. So right now we have one deputy prosecutor, and of course there's a possibility of having two deputy prosecutors. This is an idea that's been discussed quite a bit, including during the discussion of reform, the reform process, where you would have the two deputy prosecutors who are in-house, and they will be dealing with, one of them will potentially just be responsible for managing the complex organization, and then the prosecutors out there basically doing the diplomacy. That's very critical with the states parties. I mean, going from capital to capital, when you talk to our good friend Stephen Rapp or David Crane or any number of these prosecutors, Hassan Jalloh, they tell you how their presence in this office, Richard Goldstone is big on this, going around the world, basically capital to capital, building some support for the institution, explaining their mandate, trying to mollify the concerns of states that sometimes misunderstand what the court is about. So I see the job as primarily a diplomatic role, but it's also very important to have someone who has experience with prosecution so that they could bring that light into the table when they're dealing with cases, concrete cases.
Okay, thanks. So you mentioned the independent expert review, and this is really a question that I want to pose to all of you. And that is the independent expert review that was issued last fall, 350 pages, about 350 recommendations, and some of it was pretty disturbing about the future of the ICC and the present of the ICC. So, for example, I was pretty stunned when I read the section that talked about how internally in the organization, there's a kind of culture of fear that reigns in all of the organs of the organization. The report talked about how there is an adversarial relationship between the prosecutor and the judges, between the judges and the registry, between the prosecutor and the registry, and then just many other issues that were administrative and internal. A couple of years ago, the Australian scholar, Douglas Guilfoyle, published a very influential 3-part blog post on Eagle Talk called simply, "This is not fine," talking about the way in which the ICC was operating. And the report seemed to confirm that this is not fine. I mean, it was, I think culture of fear is scathing. I think mostly the language of the report was very diplomatic. But I am wondering whether this is a question really for all the panelists. I'm going to ask Todd first, but then I ask the others of you to jump in. How not fine is it? Is the ICC an institution that is in trouble? Is it an institution that is in the process of righting itself? I think that Philippe Sands was absolutely right today when he said, of course, courts and tribunals can't be the end of the story for international justice and accountability, but they certainly are part of the story, and the ICC is the story right now. So how should we read this expert report, and what should we take from it? And is it something for us to be gloomy about or optimistic about? And so I'll just start with you, Todd.
Thank you, David. So the report itself is, as you say, it's remarkable. It's really in depth. It goes through a zillion issues. It seems to be insightful. I'm not a court insider, so I don't know, but it's, so the report itself is a positive step. Some of the things it talks about are, troubling, as you say. Your question, can the court right itself? It's like all of these questions, none of us really know for sure. The thing I think about as a former US government person is it's a mistake for the US government to think that our preferred outcome is that it not right itself, that it sort of not survive. And I think there is a current of that in some places in the way people think about this. And I think that's just a mistake. There's far too much good that we get out of the court. Notwithstanding the concerns people have about Afghanistan and Palestine, there's far too much good that to me that could conceivably be in our national interest. One of the problems the court has, I think, is that it's so many different. One of my colleagues, when I was in the legal advisor's office, one of my foreign colleagues said the problem with the court is that it's all things to all people. There was a problem. Well, throw the International Criminal Court at it, and it has to. I think going forward, it has to sort of find its survivable or the lane in which it can best flourish. And the lane has to be a lane, I think. It can't be, as you say, it's not the only, it will never work if its responsibility is to deliver all of international criminal justice. That just can't sort of happen. And the report sort of has, it seems to me, sort of two kinds of critiques or sort of two kinds of issues. And one is sort of the problems in the way the court is executing. Right, so the judges snipe at each other, or the prosecution and the judges don't get along, and this kind of thing, or they don't present cases that are strong enough. That's a question of execution, and those are hard questions to deal with. But they're dealable with, and I sort of take that back. Some of them are more dealable with than others. It depends what the problem is. So one of the issues that they talk about is the process for selecting judges is not great, and it produces judges that are not as good as they should be producing. Which is a pretty stunning thing to say in a report like this, but that's what they say. If it's true, it's not that easy a thing to fix, because this is not the only multilateral institution that chooses important people. And they sort of trace it back to the idea that the states aren't nominating the best people, states are trading votes with each other, and sort of like they're voting for people, not necessarily because they're the best person, but because my state has a candidate over here in the WHO, whatever it is. And so you end up with less than the ideal group of judges. So I don't know if it's true or not true, but it's not an easy thing to fix, because that's what states do. They have other interests too. It's not their only interest isn't the ICC. And I think they actually say in the report that you can't really sort of stop states from trading votes. You have to get it at it in other ways. So the things like that even though there are questions about execution of a mission that still are going to be hard to fix. But to me, the bigger issue is the questions it raises about the mission. It's the definition of the mission. And they get at this in, I have it someplace. It says that they heard, the experts heard sort of repeatedly that the court should focus on a narrower range of situations. The court should focus on a narrower range of situations and limit its interventions to the extent possible, focusing on situations of the highest gravity and on those most responsible for the crimes. While it is a prospect that would be disappointing for many and further shift the already limited jurisdiction of the court, the current situation is unsustainable, having regard to the limited resources available. And some people will say, well, they should just give them more resources, but that's not going to happen. It's just not going to happen. And it's certainly not going to happen until the court performs better in the first place. So this is a real issue for the court, how to sort of conceive of, what's in its lane, what is it assuming responsibility for. And honestly, when I read the report, that passage I just read focused on, well, they need a higher gravity standard. And to me, I think they need to sort of rethink a lot of their standards, actually, that they don't quite have complementarity organized in a way that's compelling to people. They need to sort of, there needs to be sort of thought given, I guess the bottom line of the whole thing, thought given to exactly what it is they're going to consider their responsibility to do and that which has to be done in some other way. I guess I should stop there.
Okay.
From the United States, can I just say one more thing? From the United States point of view, the United States has concerns about the court. And basically the concerns about the court is that, well, at least they can exercise jurisdiction over Americans, they're going to be bumping into it, right? And we are bumping into it in Afghanistan. And Afghanistan is sort of a strange situation, right? The torture allegations are not the normal thing that happens. I mean, it was a point, hopefully, it was a point in time in our history, in a way the country panicked and so forth. It's not clear that that's the kind of thing that's going to recur. But the court has such a wide lane and such a low bar, it seems to me, such a low bar for what it considers its responsibility, that with that low bar, it'll bump into us a lot more. So the United States, too, has an interest in the court sort of finding a better defined, better articulating the set of circumstances in which it will be involved. And that's part of the reason I think it's so important for the United States to, in some way, engage. I mean, we're outsiders, but in some way to engage or at least to contribute to this discussion that I think is going to happen over the next couple of years.
Okay, so just two buckets of problems, problems of execution and problems of what the mission is. And you mentioned the gravity threshold in those, and Meg has literally written the book on gravity. So I'm wondering what you took away from the independent expert review, and do you think that the mission should be redefined with a high gravity threshold, a low gravity threshold? And just to say a word for those who are unfamiliar with the statutory scheme, the Rome Statute requires that that there be a finding that the situation is grave enough to warrant that kind of international attention. So I'll turn this over to you, Meg.
Yeah, so I think the independent expert review process was fabulous, and I'm so glad it happened. And I want to echo, before I get to the gravity part, just some of the things that Todd said about the mission as well. However, I'm an optimist by nature, and I think we need to take the long view here. And as somebody who participated in the Rome Conference in 1998, as many of us here today did, many people did not think that the court would become operational in our lifetimes, let alone be where it is today as an important player in the global legal order. So I think we have to view it as a glass half full rather than half empty, acknowledge that there are a lot of challenges, and a lot of those challenges do relate to the ambiguities in the court's mission. And this is actually something I've been writing a little bit about recently. The court was set up without a very clear mission. There was this sort of general idea that a lot of really bad things were happening around the world, and that drawing on the legacy of Nuremberg, criminal prosecutions could be part of the solution. And that the international criminal tribunals for former Yugoslavia and Rwanda in particular, and Sierra Leone, that later, were showing us that criminal prosecutions could contribute in some positive way to something, right? It wasn't exactly clear what and how. And so this is partly how we ended up with this very ambiguous mission. And many people talk about the court as being this court of last resort that's only supposed to prosecute the worst of the worst. But the Rome Statute is not actually set up to reflect that mission. So I think there's a disconnect between the rhetoric surrounding what the court was set up to do and what the statute actually instructs the actors on the ground to do, or at least how they've interpreted what it instructs them to do. And I think that has contributed to the court feeling a lot of pressure, right? It's a court that was established in a highly political environment with, as you said at the beginning, some of the world's major powers, not supporting the court and sometimes actively fighting against the court. And then in addition, to have this very broad and ambiguous mission and this statute that doesn't really tell them clearly what they're supposed to be doing, it's a very pressurized situation to be working in. So I don't think any of us should be particularly surprised that there are a lot of issues in terms of execution, in terms of culture, that the people there are under a lot of pressure. To answer your specific question about gravity, I think that the court needs to be very careful about using the gravity threshold for admissibility, right? This provision in the statute that says that in order for a case to be admissible, and ultimately a situation with cases to be admissible, the cases have to be of sufficient gravity to merit action by the court. If the court interprets that in a way that limits its reach, there's really in my view, no principled way to do that. And so it's very likely to undermine both its legitimacy and its ability to be effective in the world in a variety of different ways. And taking the long-term view, I think that would be really unfortunate. At the same time, I completely understand why many actors at the court, and as Todd said, sort of want the lane to be narrower, right? They want to know what it is they're supposed to be doing. And gravity is a sort of tempting way to narrow the lane and say, well, we're just going to take the most serious cases, the most responsible perpetrators, and so on. I think that this needs to be done as a matter of looking within the statute for a way to provide more discretion to the prosecutor, ideally, perhaps with some review by the judges. And I've argued before that really the way for this to be done, rather than trying to read in some kind of substantive criteria to the gravity threshold, which is essentially jurisdictional. It's admissibility, but basically, if they say, for example, in order to be admissible, the case has to involve at least 100 victims of crimes as bad as murder and rape, right? Then that essentially limits the subject matter jurisdiction. And the same thing can be said of any kind of limits that are placed on the kinds of perpetrators, level in the hierarchy, et cetera, is going to effectively limit the personal jurisdiction, even though it's called admissibility. So I think it has to be done differently. And I've been banging this drum for a while and nobody's picked up, it's really taken it up, except to a limited extent in the Afghanistan situation. And in a very controversial decision. So the argument that I've made in various places is that the way to do this is to look to the interests of justice, which is another very ambiguous, undefined concept in the Rome Statute that could be read to provide the prosecutor more discretion with some review by the judges to select situations that are relatively more serious, rather than saying these are insufficiently serious to merit the court's action, to say, well, with our limited resources, we're going to focus on these situations, which for these reasons we think are more important, in terms of our mandate, in terms of what we can accomplish in them and so forth. The court actually did use interest of justice in a very controversial way to say that the lower court, the trial chamber, to say that the court couldn't proceed with regard to Afghanistan, and then that was reversed on appeal, and the judges said that had been an inappropriate use of the interest of justice. I agree that was not the right way to go, but it was sort of a nod in the direction that I think could be an appropriate way to go. In that case, they had essentially said that, because the prosecution wasn't likely to get access to the kind of evidence that they would need to prove the case, that it wasn't in the interest of justice to go forward. And that was seemed like a kind of a lame excuse for a political decision. Excuse Lily. However, I do think—
fourth panelist.
Yeah, exactly. Fourth and fifth, actually. Hopefully he won't join in. I do think that using the interest of justice in a way that enables the prosecution to have a little bit more discretion to do a kind of relative gravity analysis could be a good thing.
Yeah, if I could just ask a follow-up about that. So just the Afghanistan decisions I thought were very interesting. When the first decision came down saying we're not going to approve this investigation into Afghanistan because the parties, none of them will cooperate, we won't be able to get the evidence and so on, so it's not in the interests of justice. I have to say my first reaction was rage. I thought, why don't you just be honest and say the interests of justice are going to be defeated here because we can't get access, but don't say it's in the interests of justice. And then the more that I thought about the argument, which was the long term of interests of justice are the court's entire mission, not the mission in any situation, it seemed like the reasoning in that was more compelling, that there was something. Yeah, I mean, if you're going to drain a lot of resources into some investigations that aren't going anywhere at the expense of the court's mission, that's not in the interests of justice. Of course, they were reversed, but it doesn't strike me that it was a completely out there argument as I thought that it was at first.
Yeah, I completely agree. I mean, and of course, in international criminal law circles, it was sort of, taboo to say anything like that because it did look like a very political decision. And, most people were arguing that it very much undermined the legitimacy of the court and so on. But I do think that looking at the interests of justice as what is it that this court's long-term and short-term missions and medium-term missions should be, and trying to align situation selections and case selections with those missions makes a lot of sense. And so I think it was sort of a nod in the right direction that didn't go over very well because of the way that it was framed. I don't think that the court did a particularly good job of explaining what you just said, that we're looking at this in terms of allocation of resources and the ability to accomplish important mission objectives in the long term. I think they could have done a better job of articulating that. But I think that could be a fruitful way to go in the future.
Thanks. Charles, I'd like to get your view about the meaning of the IER and about whether the court is fine or getting fine or it's not fine. And, I think that this is especially important because, over the last few years, we've overall seen a kind of waning interest in internationalism and international law. And, heightened nationalism, more prickly responses from states. And that kind of makes it seem as if the court is trying to sail when the current is going the other way. I'm wondering what you took away from the review.
Thank you so much, David. Look, maybe it's a survival strategy, but like Meg, I tend to look at the glass as half full rather than half empty. Let's think about the context. It took the international community over 50 years of deliberation to get a permanent international criminal tribunal. The idea was discussed in the context of negotiating the Genocide Convention in that ad hoc committee of the General Assembly that gave us the Genocide Convention. We know they gave us the placeholder. We know the subsequent steps and the back and forth between the General Assembly and the International Law Commission, where I have the privilege of serving, and this on and off proposition of a topic called the question of international criminal jurisdiction. We know how that culminated at the right time for a variety of historical reasons. The fact that Trinidad and Tobago, in its wisdom, decided to ask for international community support, worried about drug trafficking, which they didn't even end up getting in the statute, raised the question at the right time. And there we are, as Meg said, we got the statute, got adopted, everybody's, oh, that's not gonna come into force anytime soon. Well, of course it did. It came very quickly, 60 states parties, quickly, right? Unprecedented. It beat every single scholarly assessment, crystal ball, the hedgehog that predicts the weather. It beat everybody's expectations. The point I'm trying to make is that the ICC is a singular institutional achievement of the international community of our time. So it's not going to be easy. So my first reaction to the report is that great job that the court had the wisdom. The presidency, the OTP, of course, was part of this registry to activate the process that led to the review process. The context we must remember is that if you think about the ICTY, the ICTR, the SCSL, all of them at different times in their early days got some kind of independent review process of what they're doing not so well and what they could do better. Of course, in the context of the Sierra Leone, it was that Kasese report. What we saw with Hassan Jalloh, that review that the international community led in relation to the ICTR, which was basically, they had given up. The international community was almost ready to give up on the Rwanda tribunal, right? Is corruption, all kinds of issues, failing cases, corruption in the registry, people were fired, okay? So we know that this is part of the process if we look at the single situation specific tribunals created. So for me, the first thing was, this is very hopeful. They recognize there are some problems. They're no longer burying their heads in the sand. They invited an open discussion about it. So that's the first point. Second point, if you look at then, of course, the very disturbing information that came out of it, as Meg said, maybe this is to be expected to some extent. And nobody's going to sit here and say that states will probably throw in more money at the ICC now. Today is not 1998. But I do feel that the ambiguity that allowed the compromise to happen is precisely the ambiguity that has become a challenge for the court, at least in part, when you think about that bucket of execution that we're talking about. I see a third point which relates to this, which is that if you think about the big picture, I think it's good that states parties have been very keen on what could be done to improve the court. Everybody was at one point talking about the crisis of the ICC and so on. But the role of the states parties themselves cannot be divorced from whatever crises or crises that the ICC is facing, including the Assembly of States Parties as a body of the states themselves, but also the individual member states. Because remember, in all of the situations that the ICC has gotten involved, it's either the countries have invited the prosecutor to come in, starting with the famous so-called self-referral by Uganda. We know how that went with subsequent African states stepping up, sending the self-referrals. We know we got to that moment where everybody was holding their breath. Would the US allow the Security Council 13B process to work out? If you think of Sudan, we got that, right? And then of course, followed quickly by Libya. But in all of these situations, there's always that compromise that was built in. So there, of course, we saw the referral came, but there's no funding that comes with the referral, which is actually statutorily required. So of course, the prosecutor comes back to the Security Council reporting every year. And one year she threw up her hands and she basically, I don't want to do this anymore. Because like a charade, I come here and report to you, I'm not getting the cooperation, and you're not backing me up, yet you are the ones that gave me the referral. So my point there is to say that I think, if you think about the design aspects of the statute itself that reflect these difficult compromises, it suggests to me at least that it needs more political cover as it's becoming more effective and getting involved in more sensitive issues. But if it doesn't have the political cover and the cooperation and the support from the state's parties, then we're going to bang on the court in whichever way we like and say, you haven't done as good a job. I'll just go to a couple of hopeful things because I do want to keep the glass half full, which is I like the stress of the ASP now in taking this process forward and having that permanent mechanism. But there are even things that tie into the issue of judicial nominations and the election of the prosecutor that are very positive. The Rome Statute provided in Article 42, if it comes to the prosecutor, essentially a mechanism where a state will nominate somebody, and it's a typical international organization thing, and they will elect the person by absolute majority. But actually, they overturned that presumption early on, starting with Fatou Bensouda's appointment, and effectively created some kind of competency search committee. They improved upon that in the most recent round. I'm not saying it was executed perfectly. We had some issues there. I happen to have been privileged to be part of that process on the panel side. But again, if they are showing the interest of prioritizing competency, I think that's already a very hopeful element. The judicial nominations, it used to be the case that you would nominate your judges, there's no check, but they came up with the advisory committee on the nomination of judges. They have now a system of qualifying individuals that will signal to states who they think is really good. They've improved upon that in the most recent resolution in 2019, actually discouraged officially vote trading. Are states gonna do it? Probably, I don't know. But my point is that states who take this position is a very hopeful thing that really goes against a long grain of practice that we've seen in international institutions. And then I just finally end with this concern that I have about the process itself. I think the process was generally good. It came at a bit of a challenging time because COVID came in the mix. I worry a little bit that the views of situation countries may not have been factored in as well as it could have. Definitely, I've heard murmurings from African civil society, for example, about African participation. I know that African states tried to engage with the process, but the process kind of like went too fast for them to some extent. So I'm hopeful that as we go forward, as we take on board these multiple recommendations in terms of what we will do, we will not redesign the Rome Statute to make it more difficult for the court to achieve its mission, as opposed to make more realistic, maybe focusing more that it will be that anchor of the system as a whole, but that there will be other mechanisms and levels of accountability, the national level. If you think about the regional level, we're now talking about experimentation with regional courts, having some role. Hybrid courts, everybody said in the past that they're no longer relevant. They seem to continue to be relevant for all kinds of reasons. So maybe the ICC would then sit in the middle and deal with those limited class of cases that will move the system forward. But my hope is that we do not go back to that world where we do not have the ICC. That's no longer, I think, a tenable proposition. So I'll end there at this point. Hopeful, I think.
Okay, some might say that one of the lessons of the ICC's history is that it's only possible to get custody of leaders after they're out of power or after they've fallen. So one, how to put it, one compromise that a prosecutor could make that was, I believe, a recommendation in the IER. Was also one of Professor Guilfoyle's recommendations, was kind of a bitter pill, and for those of us who thought that the mission would be that nobody is immune from prosecution, and that is to go after mid-level leaders only, those whose hands are more directly involved in the crime. I think that this was one of the lessons from the jurisprudence of the Bemba case, which made it very, very hard to prove command responsibility for a remote leader. And I'm wondering if that's too bitter a pill to swallow, that the mission is going to be go after mid-level leaders, don't go after powerful leaders that are still in power, because it's a hopeless quest. And this is, Todd.
I was going to say it depends exactly what the pill is, right? The pill could be go after mid-level people first to build up, or the pill could be reluctant maybe because of the, whatever, but don't eliminate it. I think if you eliminated the possibility, it would be really quite a bitter pill. Because in most of these situations, if you sort of think about it from a diplomatic point of view, in most of these situations, if you see atrocities occurring in another country, forget about the court, right? You see atrocities occurring, what you try to do is press your point at a high enough level so that the word can get down. Or you can't go to each soldier who might commit a war crime and say, don't do it, don't do it, don't do it, don't do it. But you can go to the commander and say, you're going to be in trouble if this is done. And it seems to me that in a way, part of the role of the court is to sort of reinforce that message, right? Most of these cases aren't ever prosecuted, but a lot of those demarches happen. And you want those demarches to be as strong as possible, and eliminating the possibility of prosecutions at sort of senior levels, I think really would sort of undermine that.
Okay, thanks. Actually, I have a question from the audience, and this is to Meg. And it takes us back to the initial question about sanctions. As you noted, the United States government was scheduled to respond to the complaint in your lawsuit today. It seems it has asked for another extension instead of responding, though I've not seen the filing. What are expected next steps for the United States government to finally respond to the two lawsuits as moot?
So there has been an extension until April 22nd. And there are still some discussions that need to be had, and I am not really at liberty to talk about some of those, but I'll just point out that there is a paragraph in the order that says something about, I'm not going to get the language quite right, but it reserves the possibility of proceeding with regard to things that have happened in the past before the order was revoked. So there are some things that still need to be worked out in terms of how the litigation will be ended. I guess that's what I can say. And so for that reason, the deadline to respond was extended, and those things are getting worked out.
Okay, thanks. And another question from the audience here. This is, I'm not sure if I think this may be directed to everyone. How do you see the choice of Sylvia Fernandez as ASP president in bringing all elements of the Rome Statute to a better working relationship because of her experience as an ICC judge, ASP delegate from Argentina, et cetera? Anyone on the panel want to jump in on this question?
I can say some.
Right, yeah.
Okay, yeah, thanks, Todd.
So very quickly, I mean, there are a couple of reactions. One is, I think the presidency of the ASP plays a critical role in the ICC, and one might argue a fundamental role that hasn't been as taken on board by the leaders of the ASP to the level that is required for the court, given the challenges that it faces. Now, Judge Fernandez was there at the Rome negotiations, by all accounts, a very experienced diplomat, and then, of course, ended up serving in the institution. So she knows the institution very well. My hope is that this becomes an opportunity because, of course, as you know, the leadership change is not just at the level of the presidency. It includes the OTP, but also includes a number of new judges in the courts, a set of principles, so to speak, throughout the institutions. The second point, though, is that I still think I don't want to necessarily say put too much stock on one individual as much as the institutional apparatus that needs to be built in terms of giving the support to the court that it needs. And I think the ASP, especially the states parties, can perhaps have pushed a little bit more, especially when you think about this cooperation angle to include the issue of funding. So in Madame Bensouda's speech at the ASP, her last speech at the ASP, she said people often ask her, what is the biggest challenge you have faced? And she explained that the biggest challenge is that she doesn't have the funding, her office does not have the funding to accomplish all the expectations that are placed upon her. So I think if the states parties are going to continue ramping up, this business of the ICC can be a solution to all things. And Todd talked about this earlier. And Meg and I think, also agree on this, that we need to have a more focused institution. We're talking about narrowing down the space. Well, if the countries are sort of subcontracting the difficult work to the court and then leaving it without the means to accomplish that goal, I think then they should look at themselves too in terms of their role. So all in all, I would say that I'm optimistic, but I do believe that that optimism has to be matched by the keen interest on the part of the states parties as the court is going along into more sensitive situations to get that political backing. And I was very encouraged that countries stepped up to talk a little bit about the support for the court that they need to give in the context of, for example, the sanctions order. But one could argue that that turnout was not that great. The turnout was there, but it wasn't as great as it needed to be for that moment. So I'll stop there.
Yeah. So if I recall, the turnout was of support for the court against the sanctions order by roughly half the states parties in the court. Yeah. Todd, please go ahead. You're muted.
During the period when I was watching the sanctions not being revoked, it did occur to me, because I thought the statement of the 67 or 74 was quite strong and striking, but I don't actually, and I don't know this for a fact, I'm not in the government anymore, but I don't think it was really followed up very strongly. I don't think Tony Blinken had a bunch of people whispering, you got to get rid of this, you got to get rid of this. And I think that's one of the reasons that it didn't happen as quickly as it might have.
And do you have any sense about why that would be? Is it that some of the states parties just didn't want to get crosswise to the United States government?
I think that there are so many issues that states have with us, and so much, I think there's a significant amount of sympathy for the new administration. It has to sort of get its feet under it and so forth. There are a lot of other issues that they have. The ICC issue, in a way, used to be, the idea of an investigation in Afghanistan, maybe I used to think would be sort of on the front page of the New York Times every day. It's in the New York Times very, very occasionally, because there's so many other things going on. There's so many crises now, or there's been so many crises the last 4 years, and it's just not as. And there's among the ICC supporters, there's a level of disillusionment in how the court has performed. So there's less salience. I think they all think it's. I think many countries think it was a really bad thing, but they have to ask themselves, is this where I'm going to use my chin? And it sort of fell down a little bit.
Okay. Are there anybody else? Anyone from the audience, please feel free to just use the Q&A function to ask a question, but let me bring one more question up, and that is the situation in Palestine. Obviously, that was one of the issues that was behind the sanctions, because when the executive order said that sanctions would be deployed in the face of an investigation of the United States or of US allies who hadn't consented, it seems as though Israel was the only US ally that was under preliminary investigation that hadn't consented, because all the other US allies that were, the UK, for example, are parties to the ICC. So now the court has approved the opening of this investigation. I imagine that there will not be much cooperation from Israel, and I have no idea whether there's going to be much cooperation from the Palestinians in investigating their part of it. So what do you see is likely to happen with the situation in Palestine? And this is obviously one of the hot potatoes that Mr. Khan is going to inherit.
I can start us off there if you'd like, David. I think it's a very interesting question, and I also don't have a crystal ball or any particular inside information about this. I think that one prediction I might make is that the pace of the investigation might be very, very slow. And we've seen other situations where the court really takes its time doing things. As Charles pointed out, I think that Prosecutor Bensouda was trying to kind of wrap up some preliminary examinations before, sort of as a gift to her successor. And now I don't know how much of a gift this particular hot potato is, but it's, I think, likely just that that nobody's going to be in a huge rush to move things forward in this situation. The Columbia preliminary examination has been open since 2004. And it's different in that there are a lot of national mechanisms sort of being evaluated, and there are conversations happening between the national system and the ICC that may not take place in this situation. But I just think that it's gonna take a while. The prosecutor's recent statement on the Palestine investigation, she made a point of saying investigations take time. So I think she's already telegraphing, we're not in a huge rush here. The other interesting thing that she did in that statement, or another interesting thing, is that she noted that the investigation will take place in the usual context of the OTP's, impartiality, just following the statute, we're just here to do our jobs, people kind of approach. But she also noted that she had declined to investigate the case involving the Israeli Defense Forces in the Mavi Marmara incident, right? The flotilla that was entering or going toward Gaza to deliver humanitarian aid. And she had declined.
That was in 2010 that incident happened.
Yeah. And she referenced it in this recent statement by way of sort of saying, hey guys, I'm not, biased here. Look what I did before, right? I said that this other situation involving the IDF wasn't of sufficient gravity, kind of getting back to what we were talking before about gravity. And, sort of using that, the way I read it, to sort of build her credibility in this situation, or build her offices, now that she's got a foot out the door, her office's credibility with regard to the investigation in Palestine. Query whether she was also telegraphing, maybe this situation also will be deemed not to meet the gravity threshold, which, could be one way. I would not recommend it, as I said before, but could be one way of avoiding having to bring prosecutions in the situation. Another possibility might be to use the interests of justice, as we were talking about before, as a way of, and messaging would be extremely critical if that were the approach that the prosecutor and or the court ended up taking. But ultimately, this is a highly, highly political situation, and brings us back to conversations we started to have about the new prosecutor, Karim Khan, and how politically savvy is he, and how much of his job is political versus legal. And I think it's going to be just really, really important for him to be, to treat this with the kind of political diplomatic delicacy that it requires. There may be some issues of complementarity. We also started to touch on complementarity earlier, where the prosecutor in her last report on preliminary examinations did note that Israel was investigating some of the crimes that were alleged to have been committed within the jurisdiction of the court. And that could still be evaluated after further investigations take place in terms of complementarity. But of course, the issue of the settlements is not going to be the subject of a complementarity challenge, since Israel maintains that those are completely legal. And then on the Palestinian side, I don't know, I have not heard about any investigations or prosecutions taking place that might fulfill the complementarity requirements to make the cases inadmissible. I don't know if others have information about that. So hard to predict what's going to happen, but I think very clearly it's going to be a fraught situation, and that will likely mean that it is taken at a reasonably slow pace. That would be my prediction.
Okay, and we are just about out of time. I have one comment from the audience. My concern with these talking points at times is that we tend to soften the language so as not to concern powerful states, especially the US and the remaining P5. For example, why should we feel the OTP should take its time for Palestine? why should we be concerned about interests of justice, non-cooperation, et cetera, more with respect to powerful states than other states, especially Africa? Now, we are just about out of time, but I'm hoping that we could take another minute or so just to get an answer to that. And then afterwards, we'll be taking a 30-minute break and reconvening at 4 o'clock for a presentation by the Human Rights Institute's fact-finding practicum on attacks on healthcare as a driver of forced displacement in Syria. But first, I was wondering if anyone wants to take a crack at the question from the audience. Yeah, go ahead, Meg.
Yeah, let me just clarify, because I agree with the sentiment behind the comment completely. And my comment about the likelihood of the prosecution moving slowly was not a normative one. I don't think that's what it ought to do necessarily, but I'm just predicting that that may be what it does just because of the nature of the political pressures involved. But I think that's absolutely right. And I think this is a place that we can credit the court for going forward in a situation in which, you know, it was being told that the US in particular was going to fight to end its life, basically, if it, you know, which we're talking a murderous US administration here, that you know, the court was pretty courageous in going forward under these circumstances, and I hope will continue to be. So I didn't mean to suggest that the court ought not to be courageous when it comes to powerful countries. I think it's very important that it does so, and that's a really critical part of its mandate, is to show that all people are subject to its jurisdiction regardless of power.
Well, I think that is that's a statement that's a good place for us to wind up our panel. And I would like to thank all of the panelists for bringing a world of insight to us about the court. And I guess the only thing that we can do with the court's future is to stay tuned, watch, fasten our seatbelts, put the tray tables up, and hope that our travel continues. So I'd like to thank you all very much, and wish you a good afternoon.
Thank you, David.
Thanks.
Thank you, David.
Thank you, David.
Yeah.
Bye, everyone.
Bye.